Okay. Let's go on the record on cause number DC 22-10595, Cantu versus Smith et al. Counsel, make your appearances.
Stacey Dunlop on behalf of plaintiff Laura Cantu.
Michelle Peters on behalf of plaintiff Laura Cantu as well.
Good afternoon, Judge. This is Sawyer Neely from the Bradley firm on behalf of all the defendants. And with me as well is Ms. Stephanie Gaston, who's a former partner of mine who recently left to go in-house at ConocoPhillips. She was the attorney on the matter during the hearing. That's the subject of this motion. I took over the case afterward, but she's here as well, although technically she doesn't any longer represent any parties.
Okay. All right, you may proceed.
Thank you, Judge. Just in the way of housekeeping, I know that there was also a setting this afternoon for the motion to compel arbitration. I haven't seen anything that says that it was actually taken off your docket, but we received an email from Mr. Neely stating that you wanted it to be heard in person and not via Zoom. Our initial plan was to have them be heard at the same time, but I'm fine with having just our motion to reconsider be heard today and having your motion to compel arbitration heard on a date in person in front of you.
Yes, Judge. Briefly, Ms. Pinson let us know that you wanted to have it in person, and
No, I didn't want it in person. I thought y'all wanted it in person.
Well, the issue, Judge, is this is an employment case. We've got an employment agreement, and I've moved to compel arbitration. But the lead argument by the plaintiff is that it's a fake or forged contract, and so I have the original, and I need to.
Okay, yeah.
I need to bring it in, and it's got the wet ink signatures. I don't see any other way to do it other than if I just send it over to you in a letter. So we're working on an agreeable date.
I do not want you to do that.
Okay. All right.
I don't
Fair
want
enough.
original exhibits.
I can work with Ms. Pinson on a date.
And one thing to kind of know about that is that courts, like the clerk keeps a record, the court reporter keeps a record. I don't have a record. I don't keep a record. That's kept by the court reporter and the clerks. And so if you give me an original exhibit, I don't really have a place to keep it. The court reporter has a place to keep it, the clerks do, but I don't. And so I don't want to be in charge of anybody's original exhibit. So
Fair enough, Judge.
I will say that when I read that motion, just to give you guys something to think about before you hold the hearing, I had a serious question about whether or not the arbitration language in the arbitration agreement itself was sufficient to order the case to arbitration, especially since it didn't give any details. It was so vague. It wasn't listed as an arbitration. I mean, I've seen at this point probably hundreds of arbitration agreements. That was the least clear one I've ever seen. I'm not saying I'm ruling on that point, but if you really want to push this issue, I'm going to want a significant amount of briefing that says something that's that vague is enforceable, and maybe something the Dallas Court of Appeals might have to rule on at some point. And then to say that I'm going to create you wanted me to use the AAA, it's not listed anywhere in the arbitration agreement. Do I have the authority to do that? If anything, I would say if we're going to have an arbitration agreement, the default would be the judge would choose, but that's neither here nor there. I'm not sure this arbitration agreement is enforceable just given the language of it. So I don't want you to just skip over that point. I'm going to need a significant amount of briefing to convince me that arbitration agreement obviously was not written by your office, Mr. Neely. Mr. Neely, there's somebody behind you. I don't know if you knew that. He seems to be.
I've got a glass
Oh,
Sorry,
I'm sorry. Okay.
I'm in a fishbowl office. I apologize. I'll turn
No,
it.
no, I'm not trying to fuss with
Wait.
you. It just was, I wasn't sure if he needed something or what he was doing, so.
No, he's probably talking about his round of golf yesterday, but I'll
Okay.
turn it this way.
Okay, no worries. I wasn't trying to fuss with
No,
you.
and Judge, point taken. I'll do my homework and be prepared.
Okay,
And it may be that I amend it and submit more thorough briefing on that issue, but message received.
okay. All right, let's do the motion for reconsideration today.
All right, thank you, Judge. You may recall, I know that you've got several cases, but some, I'm sure you memorized the ones that I'm on. You may recall that we had a set of motions set in front of you the last time we were in front of you. Those namely being a motion to compel that we filed on behalf of Ms. Cantu, and also the motion to quash that was filed by the defendants. The motion to compel was heard first, and during that motion to compel, at the end, Ms. Peters argued for attorney's fees, and you gave your normal talk about you don't like to do it the first time. You'd like to sort of give
That sounds exactly like me. I've given that talk many times.
and I've heard it a few times. And so, you gave your normal talk about, hey, let's give them a little rope. It's just but you concluded the talk with what you normally say is that, but you have noticed now, watch it because that's your strike. That's your strike.
Yeah, that sounds right.
So then the motion to quash came up, and because it was their motion, but because I had said it to talk about it, you allowed me to go first. And so I explained to you, namely the timeline on how things went. First, that I had asked for some dates by email for the taking of the depositions of the two main persons in this lawsuit for the defendants. And then I did not receive a response. I indicated during that timeline that I did not receive a response to that email. And then after not receiving a response to that email, that I then went on ahead, after 3 weeks of waiting for a response, I went on ahead and noticed the deposition. And then the motion to quash was filed the very next day, and we ended up having those quashed. When it was time for Ms. Gaston to respond, when it was her turn to respond, and by the way, she was the one who was arguing she was the one who you were giving your talk to about the denial of why you were not going to grant our request for attorney's fees. She was the one who was arguing on behalf of the defendants for the motion to compel. So when I finished giving you the timeline and making the argument that you ought to compel the depositions and that you should award fees, Ms. Gaston indicated, she began with that there was something wrong with my timeline and that I was mistaken, and that I didn't tell you properly that she did indeed respond to the email, and that make something to the effect of that she responded saying, give me some time to talk with the defendants to come up with some dates. Now, I wasn't prepared at that moment to confirm that. I was actually surprised by the statement, but I thought perhaps maybe an email had gone to spam, or maybe it had gotten lost in cyberspace or something like that. So I wasn't prepared to contradict that. I felt because I haven't been in front of you a lot, but I have been in front of you a few times. And I just, I was concerned that as it stood, it made it seem like was perhaps misleading the court or trying to mislead the court as to the timeline. But I wasn't sure what was going on as far as whether she really sent an email or not, or maybe I missed it, maybe I saw it and blanked out or whatever. So after the hearing was over, oh, and by the way, Ms. Gaston also said that, hey, by the way, I'm prepared to give you dates now, which the normal playbook when you file your motions to quash would be to say, hey, those dates that you picked won't work. So I'm filing the motions to quash them, and here's some more dates. Typically, it wouldn't be, you would wait until the hearing on the motion to quash to provide dates. So after the hearing was over, I then looked and combed through all of my emails, tried to find any correspondence between myself and Ms. Gaston that would confirm that she did respond to the email. When I didn't find it, I sent her an email saying, hey, listen, you're on this case, we're on this case, we need to make sure that I'm getting these emails. I never received one from you. Can you confirm that you sent one? Initially, that request went unanswered, and then I asked again, and then Ms. Gaston said that she would look for it. I thought it was peculiar that she would need to type a response saying I'll look for it rather than just typing to, but ultimately at some point it became clear that after she was off the case, that she never did respond at all to the email. And so what I'm asking you to do, Your Honor, is reconsider your granting of the attorney's fees that we were requesting, and to also award or to impose some sanctions for the misrepresentations to the court. And that concludes my argument.
Okay.
Judge, I don't think I'll take but about 3 or 4 minutes. I don't think that sanctions are appropriate in this case. I think that
well, first off, let me just ask this: is what Mr. Dunlop say, is that correct? Did Ms. Gaston say that she had responded to the email and then she actually hadn't? Is that accurate or not?
I think so. I wasn't at the hearing and I ordered the transcript, but court reporter was on vacation, and I hope it was a good one. But unfortunately, Ms., I don't have the transcript. And so I think that the problem I had is I offered to Mr. Dunlop to email the court. And I tried to offer, I was like, is there some way I can resolve this? Was the first thing that hit me when I got involved. And I said, is there some way I can resolve this to your satisfaction? And I looked for the email, I didn't find it. I said, I'm happy to call or email the court and say, Mr. Dunlop, you didn't misrepresent anything. And if Ms. Gaston said that she emailed, she was mistaken. I don't have the ability to say she affirmatively said it or she says she thinks she said it.
Ms. Gaston, let me just say,
there.
Did you say that or not?
Sure, Judge. My recollection is that my response on the topic of defendant's motion to quash was that I attempted to confer with plaintiff's counsel about deposition dates. I was making the point that Mr. Stacy's email did not go ignored, and that I did in fact reach out to discuss prior to filing those motions to quash the depositions. That's my recollection. And I too, in addition to Mr. Neely, attempted to resolve these issues directly with Mr. Stacy prior to him filing the pleading that's currently before the court today.
All right, go ahead, Mr. Neely.
Yes, thanks, Judge. I having not been there, I can't say one way or the other, and having not been there, I don't have the transcript either. But I think what I do know is that there's really no showing that Ms. Gaston made any intentional misstatement to this court. And there is certainly no harm because Mr. Dunlop was successful on the motion and the depositions took place. Now, there was an issue with the depositions because it took place at Aiken Gump and I had the wrong address, and there was a whole issue that I unfortunately had to involve the court with down in San Antonio, but they took place. And so I don't know that the function of sanctions is not well served here, because someone says something in oral argument and then they go back and they think that you've misspoken. I put in my response that Mr. Dunlop did not make any misstatements. I made sure to clarify that for the court that anything that occurred at that hearing, I've confirmed there was no email that was sent back. I found some emails in April between them. I found some phone records, but I didn't find anything in March, so there was no response. But I think that my offer to clarify on the record that Mr. Dunlop didn't make any misrepresentation, and that Ms. Gaston, whatever the form of her statement, I clarified that there wasn't an email response that I found in our email system, should be sufficient. I take very seriously my role as an officer of the court. I've actually never filed a motion for sanction. I've been practicing for 20 years or so. I've never had one filed against me. So decorum, I came up under a guy who decorum is everything. And so I just don't know that this would meet the standard.
Who did you come up with?
Dick Sales.
Oh, yeah. Okay.
Who was quite a taskmaster and very strict. So I just don't think that the showing has been made. I don't think it would serve the function, particularly because Mr. Dunlop was successful, obtained the relief he was looking for, which is those depositions, and they took place. I certainly don't think the clients have anything to do with it, regardless. And so that's really all I have to say, particularly because I came in after the fact.
Mr. Dunlop, I guess what are you trying? I fully understand why you were concerned, and let me just say that I do. If somebody said, "Hey, look, you're misleading the court," I will say this: that there's certain attorneys that when they come into my court because of their past actions, there was one that near the end of my last group of interns, this attorney that has lied to me on many occasions, no credibility. I remember attorneys like that. I honestly don't remember this. So whatever was said, I don't feel, oh yeah, Mr. Dunlop's that guy who didn't tell the truth. I don't remember that. I see a lot of hearings. I understand though that you want to protect your reputation, and that's important. I think that's absolutely understandable. My hope is in belief really is that Ms. Gaston probably did not mean to mislead the court. I do feel there needs to be something done. I'm just not sure what the right thing to do is. Monetary sanctions seem a little harsh, but what do you think, Mr. Dunlop?
Thank you, Judge. I appreciate that. One thing I'd like to suggest is that since Mr. Neely has ordered the transcript, that we wait for the transcript to come, and then that way we can actually see and confirm what was said by Ms. Gaston. And secondly, Your Honor, I attempted to, by email to both Ms. Gaston first, and then later with Mr. Neely, come up with a solution that didn't involve us having to have a hearing. Namely, I said, hey, listen, in essence, to Ms. Gaston by email, listen, if you find the email, great, we'll let it sit the way it is. If you don't find the email, then the court is left with two possible perceptions of me. One is that I'm sloppy and made a mistake in saying something that I didn't make certain before I said it, or two, that I'm just lying when I gave the timeline. And while both are unacceptable, the second is horrible. So I said, if you want to make it right, if you can't find the email, go ahead and just email the coordinator saying, hey, will you please alert the judge and let the judge know that I misspoke in saying that I responded to Mr. Dunlop's email. But neither Mr. Neely or Ms. Gaston were prepared to say something as direct as that. They either wanted to make it be more squishy with, she may have said something like that, or she might have thought it was going to be a telephone call or something like that. But my suggestion as far as what to do is, first, perhaps since the transcript has been ordered, we wait to see what the transcript really does say. And then if the court determines that it was a bright line statement. That
Can I make a suggestion here?
Oh, sorry, yes.
This is not an order. This is a suggestion, if you guys agree, is let Mr. Neely request the transcript. And if it doesn't say what you say, it says, Mr. Dunlop, this is just dead. If it does say what you believe it says, and she did misstate, then what if Mr. Neely's firm donates $500 to a charity of your choice? Pick something that's not too, crazy or anything.
No, it was
Westboro Catholic Church or Westboro Church or whatever.
Sure.
I'm not trying to be political, but you know what I mean. Just something that's reasonable, a reasonable charity. How would you feel about that for both sides?
I like that, and I would be satisfied with that.
And it wouldn't be a sanction. It would just be something you guys. What do you think, Mr. Neely?
Judge, I'd love to work it out off the record. I think if the transcript says something to support Mr. Dunlop, we'll make the charity donation. If it doesn't, it's dead.
I like that, Judge.
All right. This has been interesting, and I appreciate you guys bringing this to my attention, and we will see you, I guess, in person. I don't mind scheduling this for this Friday if you'd like for that other hearing, but if you need more time to brief it, we can do it at a later day.
I think, Judge, because of your message, I want to make sure I do my research. And so I'll probably amend it and set it for a later date, just so I've crossed all my T's.
Just remember to set it on a Friday, because that's when our in-person.
Okay.
So,
yes, Judge.
right. And it doesn't have to be this Friday, but some Friday in the future. All right, guys, it's great to see all of you, and we will see you on the next one. Okay.
All right.
Thank you, Judge.
Thank you, guys.
Thank you.
You know what? It's interesting. And Tony might remember this. There was a judge. This made the Texas lawyer. There was a judge who did something very much like that. Because I'm thinking, like, what should I do in this circumstance? I mean, this is kind of a weird one where you have. She may have lied about that. If she did, she shouldn't have. I don't like to sanction people, but I understand why he was so upset, because he was made to. I don't even remember this, so it wasn't that bad, but he felt it was bad. What is a way? What's kind of a fair approach that will kind of save face to both sides? But
cut off your YouTube.